3, 2, 1, start. Section 2 Building description of the suit property given in the schedule of the plaint only 2 kathas of land. However, in the plaint and also in the lease agreement, several constructions on the land were shown and was admitted by the tenant. It would come under the definition of building under Section 2B of the Act, even in case where originally the premises was a vacant land and subsequently the tenant makes construction and pays rent for the entire premises. The said premises cannot be legally called a vacant land and cannot be legally deemed to stand out of the definition of building. Provision of the Act would be applicable. Section 11 Eviction suit landlord-tenant relationship. All the depositions made by interested witnesses, neither tenancy created in their presence, nor had they seen any document with regard to tenancy, nor rents even paid in their presence. Court below rightly rejected their evidence. Full stop. Section 11 Eviction suit. In a suit for eviction, question of title has to be gone into only incidentally and not in a full-fledged manner. Any finding with regard to title, even if given in impugned judgments, will not create a bar upon the parties to file a title suit with respect to the title over the suit premises to be considered on its own merits. Full stop. Section 11 Suit for eviction on the ground of expiry of fixed period of lease suit by one of the co-landlord who jointly executed the deed of lease has full right to file the suit for eviction when the other co-landlord never objected to the claim of eviction. Full stop. Section 11 Eviction on the ground of expiry of fixed period of lease. The lease was not extended. Acceptance of rent from tenant by landlord after expiration of contractual tenancy will not mean that the landlord has assented to a new contractual tenancy. It is the duty of the lessee to vacate the leasehold. But if he continues and the landlord accepts the rent, he becomes a tenant on sufferance and hold merely through the laches of the landlord. The expiry of the fixed period of lease is well proved, and the tenants are liable to be evicted on that score alone. Full stop. Section 11 Suit for eviction on the ground of expiry of fixed period of lease and also on the ground of personal necessity. Landlord proved his case on both counts. Finding regarding partial eviction is not given by the court. Eviction cannot be assailed on that ground because such plea will be available only where the suit is based on the sole ground of personal necessity. Full stop. Section 11 Suit for eviction decreed ex parte application by the tenant to set aside the ex parte decree was dismissed on merit which was never challenged. The tenant cannot legally raise the same plea at this stage of revision. Again, furthermore, the eviction suit tried under Section 14 of the Act and the statement of fact made in the plaint will be legally deemed to have been admitted by the tenant due to their intentional non-appearance in the eviction suit number, illegality in the impugned order of eviction. Full stop.